Now, once again, welcome student. Here we are going to discuss a very important topic, maintenance under Hindu law. Now, this topic is not specified only with Hindu Marriage Act 1955, but here I have included Hindu Marriage Act 1955 as well as Hindu Adoption and Maintenance Act 1956, and the third one, which is very important, that is 125 CRPC. What is the basic issue regarding all these three different acts? The basic spirit or the basic scope or objective behind all these three acts is that under Hindu Marriage Act 1955, the provision of maintenance 24 and 25 is exclusively dealt with the rights of husband as well as wife. It means the wife and husband can avail this right of maintenance under Hindu Marriage Act 1955. This is the only exclusive right under any personal law. Like such right is not available under Muslim or under Christian or Parsi or any other law, but exclusively this right is available under Hindu law, Hindu Marriage Act 1955, as per section 24 and 25, that husband as well as wife both can avail the right of maintenance against each other. The second one, what we are talking about is Hindu Adoption and Maintenance Act 1955, that is section 18. Section 18 exclusives is all about the right of wife only, where wife can claim maintenance without any termination of relationship or without the divorce application, right? So it means the wife can claim the right of maintain the section 18 into Adoption and Maintenance Act. Only wife can, but not husband. And when we are talking about section 125 CRPC 1973, here also the right only goes to wife and not to the husband. So here we are, this is basically a common topic of maintenance under Hindu law. So here I'll include Hindu Marriage Act 1955 as well as Hindu Adoption and Maintenance Act 1956. So students, so first of all, let's start with it. What is the definition of maintenance? Definition of maintenance exclusively is available under section 3B of Hindu Adoption and Maintenance Act 1956. And what does it mean? Exclusive, though the word maintenance is not described or explained anywhere else. It is not conceptualized actually. Actually, what maintenance include, what it consists, actually it was given by this section 3B of 1956 Act, that is Hindu Adoption and Maintenance Act. So what does it mean? Roti, kapda, makan और शिक्षा और आपकी जो medical सुविधा है, ये these all 5 things are included. It means food, shelter, क्लोथ, मेडिकल और जो भी आपका सैनिटेशन या इस तरह से जो भी आपका है रोटी कपड़ा मकान, जो भी इस तरह, ये आपकी 5 सुविधा बेसिकली, इट इज ऑल बेसिकली गिवन अंडर द डेफिनेशन ऑफ सेक्शन 3, as well as the right of an unmarried girl for the marriage expenses it is also covered within the purview of the term maintenance. Student, maintenance basically is a statutory right. It is not, this maintenance right is not a right which is only given to the wife or husband after the codification of laws only. It was a right which was actually prevailed in the classical law also. So here we are talking that how basically what type of law is there regarding Hindu maintenance. So let's start with it. So very first of all, here I would like to tell you that section 24 and 25 exclusively talks about the maintenance right. Now these two sections are very simple. These two sections are very simple in the terms that section 20, the basic line of difference between 24 and 25 is 24 talks about the pendant right. That is the right of maintenance during the pendency of the suit. When any suit of matrimonial relief it means section 9. That is section 9, Hindu Marriage Act 1955, restitution of conjugal rights. Section 10, judicial separation, Hindu Marriage Act 1955, section 11 and 12, and section 13 basically. Section 13, divorce under Hindu Marriage Act 1955. So if any such suit is pending in the court and the parties are not able to bear the expenses of the court as well as not able to survive for the sustenance of life, for the living of life, basically if some money और इस तरह से अगर कुछ चाहिए पैसा वगैरह, so what, the party has a right to file an application during the pendency of the suit for the maintenance. It means what I'm talking about is that basically it is a statute. This right is governed by statute exclusively. So here it is. Now for section 25, as I have already told you, this is a pendent right. It means during the suit, during the pendency of the suit, right of maintenance may be. Achha, there is no. And 25, if I'm talking about 25 also, so you can see 25. So what is the difference? Section 25 is a permanent alimony or maintenance. So what is the difference? Difference क्या है दोनों में? Similarity husband wife दोनों को मिलेगा. Either it is a case of a 24, either it is a case of a 25. तो दोनों में मिलेगा. But similarity क्या? But dissimilarity क्या है? Dissimilarity क्या है? ये है कि section 24 pendency of the suit है, while section 25 after the complete decree of matrimonial relief hai, after the end of the trial of the suit, and when the decree has already been passed for 9, 10, 11, 12 and 13 of 1955, then only section 25 is applicable. So this is the basic difference, and of course this is a right which is applicable to both husband and wife. So here like if I'm like, let's see that what 24 is. That 24, it means that 24 pendant light and expenses of proceeding, application of the provision confined to the spouse only and to the best of our children. It means spouse only means अगर हम ये line पढ़ते हैं confined to the spouse, it means only husband and wife. मैंने आपको बोला सिर्फ पति या पत्नी, यानी कि माता पिता बच्चे ये सब नहीं, सिर्फ पति या पत्नी के मध्य जो भी बात है वो सेक्शन 24 के अंदर में कवर होगा, 25 में कवर होगा, है ना. 26 में नहीं, 26 बच्चों के लिए है. सेक्शन 26 हिंदू मैरिज एक्ट 1955 फॉर द चिल्ड्रन, बट 24 एंड 25 एक्सक्लूसिवली डेल्ट विद द राइट ऑफ स्पाउस ओनली. सिर्फ स्पाउस से संबंधित अधिकार है मेंटेनेंस का 24 और 25. तो नो अदर पर्सन कैन गेन मेंटेनेंस हियर एक्सक्लूसिवली. दिस इज अ वेरी इंपॉर्टेंट केस. लाइक मदर इन लॉ, अगर हम सासू माँ की बात कर, सासू माँ मतलब अगर मैं किसी की बहू हूं तो मेरी मदर इन लॉ से क्या मैं मेंटेनेंस ले सकती हूँ? मदर इन लॉ से क्या मैं मेंटेनेंस ले सकती हूँ? वेरी गुड जजमेंट, वेरी ब्यूटीफुल जजमेंट बाय Allahabad High Court, Amit Kumar Sharma versus 5th Additional District Judge 1994, that mother-in-law cannot claim maintenance under this section. तो mother-in-law इसमें आपको ना तो आप mother-in-law से आप मेंटेनेंस आप इसमें ले पाओगे और ना ही वो ले पाएगी. तो कहने का मतलब क्या, ओनली दिस सेक्शन इज एक्सक्लूसिवली कन्फाइंड टू स्पाउस ओनली. सिर्फ पति और पत्नी, पति पत्नी से और पत्नी पति से, इसका मतलब दोनों आपस में. ठीक है. And this order of maintenance under this section may be made in any proceeding, either 9, 10, 11, 12, 13 under the Act. An order of maintenance under section 25 is made during pendency of the above proceeding. ये हम अभी भी बात कर चुके हैं इसके बारे में. Now, what is the assessment of quantum of maintenance? This is same provision equally applicable to both for section 24 and 25 of Hindu Marriage Act 1955. दोनों कि कैसे आप मेंटेनेंस का अमाउंट कोर्ट डिसाइड करेगा, क्या पैरामीटर्स हो सकते हैं, क्या टेस्ट है कि आपको 5,000 रुपए महीना दिया जाए या 10,000 रुपए मंथली दिया जाए या 5 लाख रुपीस आपको लमसम में दिया जाए या 5 लाख रुपए आपको ईयरली दिए. हाउ इट इज टू बी डिसाइडेड? Who will decide? What are the grounds? What are the parameters? So how the quantum of maintenance is assessed? So for this reason, though there is no specific ground, there is no specific criteria to decide what is the quantum of maintenance. But here a very simple line that the condition, the financial, social and economical condition of the petitioner, having regard to the petitioner own income and income of the respondent, or has no sufficient income. So it means what is required? The financial status of respondent and defendant, दोनों को बराबर बराबर कोर्ट चेक करेगा, दोनों को बराबर बराबर कोर्ट देखता है. खास करके जो देने वाला होगा, जो मेंटेनेंस पे करेगा, उसकी इनकम, एक्सपेंडिचर, नंबर ऑफ डिपेंडेंट्स, रिक्वायरमेंट्स, रीजनेबल वांट्स ऑफ द पिटिशनर, that all is to be considered properly for to decide the quantum of maintenance if it is a case of a 24 or it is a case of a 25 under Hindu Marriage Act 1955. So what is mandatorily required? You have to keep in mind that section 24, the basic line of difference between 24 and 25 is that the 24 is applicable during the pendency of the suit, while 25 is applicable after the complete termination of the suit, that is after the decree of the competent court. For a decree, और decree किसका होना है? 9 का होना है, 10 का होना है, किसी का भी हो सकता है, 9 का, 10 का, 11 का, 12 का, 13 का, इनमें से किसी का भी डिग्री हो सकता है. ठीक है, तो यहाँ हम 25 के बारे में देखेंगे कि 25 we are talking about permanent alimony and maintenance. It is a right of either, it is a right on either spouse to claim maintenance, permanent alimony or maintenance. Dayal Singh Bhajan Kaur ka case, and this amendment was after 1976. The order under 25 is available after final decree of any of the matrimonial relief, that is 9, 10, 11, 12, 13. ठीक है, एंड देयर इज नो बार. अगर ऐसा नहीं होगा कभी भी कि जैसे अगर किसी सूट में ड्यूरिंग डिपेंडेंसी ऑफ द सूट सेक्शन 24 का ऑर्डर अगर मैजिस्ट्रेट ने किया है, तो ये कतई जरूरी नहीं है कि 25 का ऑर्डर नहीं होगा. देयर इज नो बार ऑफ दीज टू सेक्शंस हियर. अगर 24 का है तो ड्यूरिंग डिपेंडेंसी होगा, जैसे फाइनल डिग्री आता है ऑटोमेटिकली 25 के एप्लीकेशन होगा, एंड the amount of maintenance and the amount of interim or the permanent alimony be given to the parties. So a right of maintenance now also includes the right to resident, that is covered under section 17 read with section 19 of DV Act, Domestic Violence Act 2005. Also it also covered कि आपका मेंटेनेंस का अधिकार, जैसे मैंने आपका रेजिडेंस, शेल्टर, क्लोथ, तो रेजिडेंस मतलब रहने का अधिकार. तो डीवी एक्ट में सेक्शन 17 रेड विद सेक्शन 19 में मैजिस्ट्रेट ऑर्डर्स फॉर रेजिडेंस. सेक्शन 17 इज टॉक अबाउट द राइट टू लिव, राइट ऑफ रेजिडेंस इन शेयर्ड हाउस होल्ड. तो वहां पे सीधा सीधा एप्लीकेबल हो जाएगा. इट मींस दिस इज आल्सो कवर्ड. मेंटेनेंस आल्सो बेसिकली, क्योंकि मैंने आपको बोला द वर्ड मेंटेनेंस इज नॉट डिफाइंड, बेसिकली इट इज टू बी देयर, इट इज दैट इट इंक्लूड सेवरल थिंग्स. So residence is a type of a maintenance. Residence is covered within the purview of the provision of maintenance. So section 19 read with 17 of DV Act is also covered here in the term of 24 and 25 also. So again, the very important is the what is the process of assessment of quantum of maintenance, having regard to the same of income and property of the respondent, the applicant, and the conduct of parties and other circumstances of the case. So this is this is only the process by which the quantum of maintenance is assessed in different cases. So these are two important sections of maintenance for Hindu Marriage Act 1955. Now let's have this Hindu Adoption and Maintenance Act 1956, which talks about section 18 specifically, the right of women, the right of wife, not women, sorry, the right of wife for to get maintenance without any matrimonial relief if she is residing separately. अगर वो अलग रह रही है एंड नाउ अलग रहते हुए भी वो मेंटेनेंस मांग सकती है बिना तलाक के, बिना जुडिशियल सेपरेशन के, बिना रेस्टिट्यूशन कॉन्जुगल है. कुछ ऐसे ग्राउंड्स दिए हुए हैं अंडर सेक्शन 18 ऑफ हिंदू अडॉप्शन एंड मेंटेनेंस एक्ट 1956. इट सेज कि देयर आर सर्टेन ग्राउंड, देयर आर सर्टेन फॉल्ट्स और गिल्ट्स ऑन द पार्ट द हस्बैंड, कि वो पत्नी जो है अलग रहते हुए, सेपरेट रेजिडेंस में रहते हुए भी मेंटेनेंस क्लेम कर सकती है. तो वो क्या ग्राउंड हो सकते हैं? And the grounds are, number one, number one is the desertion. What I told you, कि without any reasonable cause, withdrawing from the society of other spouse without a reasonable cause, at least for more than 2 years, कम से कम 2 साल से ज्यादा आप अलग रह रहे हो, कुछ इस तरह का आप कर रहे हो, तो पत्नी मांग सकती है. Cruelty, mental as well as physical. Leprosy of husband has any other living wife, that is bigamous. Husband keeps a concubine, husband ceased to be a Hindu, धर्म पर, और कोई भी दूसरा cause. This is a residuary clause. Other proper, ये जो last वाला जो हमारे पास है, other proper cause है, मतलब basically legislation is, this is basically a very beautiful interpretation, कि basically this is a रेजिड्यूरी क्लॉज, कि अगर मान लीजिए विद द डेवलपमेंट ऑफ टाइम अगर कोई और एक्ट भी आ जाए जिसके कारण हम मेंटेनेंस मांग सकते हैं, जैसा कि हम मानते हैं लिव इन रिलेशनशिप, पैलिमनी वी आर आस्किंग फॉर इट. तो पैलिमनी इज जस्ट टाइप ऑफ अ मेंटेनेंस राइट within the definition of live in relationship. the partners are asking for it. तो अदर प्रॉपर ग्राउंड में तो वो रेजिड्यूरी एक लाइन छोड़ दिया है कि वो कुछ भी उसमें वो ऐसा सभी कुछ कवर हो सकता है. एक रेजिड्यूरी क्लॉज निकाल दिया है लेजिस्लेचर ने, where the parties can ask or the partners or the spouse can ask for the maintenance without any matrimonial relief while they are living separately. So this is a very smart interpretation, very smart act of the law. Okay? So here we are talking about that this is what section 18 exclusively talks about. Maintenance was the principle of Hindu joint family. It was also a principle of classical law. So here it is, section 18, maintenance of wife. The obligation to maintain a wife is personal in character. ठीक है. Husband मतलब husband is always liable to pay such amount of maintenance. Number 2, this obligation arises due to the very existence of the relation between the parties, that is the marriage. अगर शादी हो, it means अगर शादी हो तो होगा, पर जैसे लिव इन रिलेशनशिप में शादी नहीं है, हम मानते हैं, but there are certain cases in which the court says, as in the light of DV Act also, if a relationship which is deemed like a marriage or in the nature of marriage, when court proved it under 114 of evidence acts also. So what? So this is a presumption of the legitimacy of relationship or marriage. So what? The court if presume कि नहीं आपका जो दो जनों का जो दो पार्टनर्स हैं उनका संबंध बिल्कुल पति पत्नी के जैसा है, शादी जैसा महसूस होता है, तो क्या होगा? वो भी हम कवर कर सकते हैं. और वहां पे पैलिमनी जैसा कॉन्सेप्ट हमने डिसाइड किया. पर स्टूडेंट यहाँ मैं आपको बता देना चाहती हूँ कि पैलिमनी इज नॉट ए लीगलाइज्ड टर्म इन इंडिया राइट नाउ. अभी नहीं, इट इज जस्ट ए जज मेड लॉ. सिर्फ एक जज मेड लॉ है कि ठीक है कुछ केसेस में कोर्ट ने कहा कि लिव इन रिलेशनशिप को डीम्ड लाइक अ मैरिज. इट सीम्स द पार्टनर्स बेसिकली आर प्रोजेक्टेड देमसेल्फ इन द सोसाइटी एज हस्बैंड एंड वाइफ, बट इट जस्ट लाइक अ कंसिडरेशन ऑन द इंस्टेंस ऑफ द कोर्ट ओनली. लॉ ने कुछ, लेजिस्लेचर ने हमको कोई लॉ नहीं दिया. तो ये तो जज मे or may not decide such concept. So this is all what maintenance basically includes: the food, clothing, residence, education and medical treatment. And the very important thing is the reasonable expenses of marriage of unmarried daughter. तो वो भी शामिल होता है. But there is but a boy, unmarried son cannot demand those expenses on the name of marriage here as per section 3B of 1956. ठीक है. You can say that it has been considered very derogatory sentence or against the right of equality. That is a different aspect entirely. But here we can say this is exclusively a right which is available only to women. Now this the forum of application under the section would be of the civil court. Of course, district court is fully empowered to do this. So this is all the general summary or explanation of Hindu Marriage Act 1955 as well as Hindu Adoption and Maintenance Act 1955. Now let's see what 125 CRPC states. Now this is 125 CRPC students. So 125, divorced wife also who have received money payable under the customary personal law are not entitled to claim maintenance under 1973 unless they are unable to maintain themselves. So what does this provision mean? Actually, this provision is all about the concept of customary maintenance. In any of the custom, if it is available by the custom or by any uses or by any ritual or right, if the party is getting maintenance, so generally there is no general application of 125 CRPC if it is available to, like meher. If I am talking about meher under Muslim law, because this 125 CRPC is a neutral law, this is a secular provision. So what? So this is equally applicable to the Muslims also. So you all know that Shah Bano Begum case. So here also I'm talking about that 125 CRPC. If parties are getting customary maintenance, so generally there is no application of 125 CRPC until and unless it is proved that such amount of maintenance which is available by the customs is not sufficient to sustain. वो आप तब तक प्रूव नहीं कर पाते, तब तक 125 का एप्लीकेशन नहीं अवेलेबल होगा, जिससे कि मैंने आपको बताया मेहर का अमाउंट. जैसे नाउ ऑफ कोर्स 125 CRPC this order is given by first class magistrate and it is a secular provision and this is very consistent as per part 3 of the constitution, that is 15(3) and 39 as well as directive principles of state policy of the constitution. And Section 18 HMA and 125 CRPC are coexistent. So order under 18 cannot foreclose remedy in this enactment. So these are very important judgment in this case. So thank you so much. This is a general provision of maintenance under Hindu law as well as secular law. Thank you so much.